I think what this industry needs is more authenticity always. Right. I'm not saying it's lacking, but that there can always be more. And certainly trial work, it's really necessary to be who you are.
That was top-rated litigation attorney Janelle Chase Fazio, a partner at Beck, Chase & Gilman. Let's delve into her remarkable career and her commitment to justice. Welcome to the Iron Mind Podcast. Join me, Josh Brumley, as we explore the minds of those who forged their paths through legal battles, business triumphs, and creative conquests. We uncover the stories behind their iron wills and innovative minds. Get ready for thought-provoking conversations, practical insights, and actionable advice. This is the Iron Mind Podcast. Janelle, can you tell us about your early career and how you started in the law?
Yes, early career. So I technically started working full-time when I was 16 and kind of haven't stopped working ever since. So I did the math on this a couple years ago because it came up in conversation, but I've worked over 20 jobs across many, many industries, including food service, retail, childcare. I was a wine club manager. I was a dance instructor. I was a high school Spanish teacher. I was a legal assistant and paralegal, all before law school. And so I was really lucky because I went into law school knowing I wanted to focus in employment law. And I didn't realize until years later how unique my work history was. Now when I work with employees, I have like a really unique understanding of what they're going through. I've been an employee many, many times. A lot of things they're going through, I've gone through as well. Right. So it really, really helped shape my practice as an employment lawyer.
What food service job did you have?
So my first job ever was TCBY, yogurt.
Love it.
I've also worked...
Delicious.
I've been a barista multiple times. I've worked in an Italian restaurant. I've worked at a deli, a bunch.
Have you had bad bosses?
Oh, yeah. Yes.
Do you have any stories that you'd like to share about a bad boss?
Okay, I won't say anything specific, but what I will say is I've definitely experienced pretty extreme sexual harassment in the workplace. I was very young. I was like 20 and just didn't really realize. I realized it was wrong, but didn't know what I could do about it. Definitely never thought about contacting an attorney, but it's something I think about when I hear from people and they tell me their facts. And I'm like, oh yeah, that sounds familiar.
And in situations where people who are victimized by a supervisor come to you, that's something that you help them litigate and you take those cases on?
Yes. I mean, it always depends on the facts, of course, and what evidence there is to be able to put on a case or get past summary judgment usually. But definitely those are cases that really speak to me.
Awesome. Well, we'll circle back to that, but I don't want to get off topic. We could just talk about everything. It's easy. So you began your trial advocacy like 3 months after you became a licensed attorney. Can you talk about that? What was it like to be in a trial so quickly out of getting a bar number?
Well, it was really fun. I started my legal career at a big regional law firm, Gordon Thomas Honeywell. It's a really great place to learn how to be a lawyer, and a ton of judges and lawyers have gone through there. And I was assigned this mentor who was a partner. He's now my current law partner, one of them at Beck, Chase, Gilman. And his name's James Beck. He had this philosophy. I'm not going to say he threw associates into the deep end. I would say he gave associates the opportunity to jump themselves into the deep end and see if they sank or swam. And he definitely did that with this trial. And he came to me and was like, I'm trying this employment case. You want to do it with me? It'll start like next week. And I said, yes, and let like future Janelle worry about what that meant. And what was so cool about it is, so we started like the court day after Thanksgiving. It went all the way through Christmas. It was like a full month-long jury trial, employment case, discrimination and retaliation. And it was great because I didn't even know enough to be nervous. Like I feel like a lot of people who've been practicing a long time and haven't gone to trial yet, there's like this pressure that builds up. Right. Where you're like, oh, God, I've been practicing 10 years, but I haven't tried a case. Like, how do I do it? For me, I mean, I've definitely made dumb mistakes in that trial, like silly evidentiary stuff that still haunts me. Um, but I learned so much. And then when I went to my next trial, it's like, oh, I've already gone to trial. Like I know, physically the nerves of walking into a courtroom, or just the sickening feeling of waiting for your verdict.
Ugh,
All
yeah,
of those things I got to learn really early. So I've felt so lucky.
that's great. And so do you have tips to overcome those things for people who maybe haven't tried their first case yet?
Yeah, I think that one big one is like just expect the nerves. It's going to feel, well, for me anyway, I feel just like sick, nervous right before I do like an opening statement. But you can actually utilize and like harness that energy because it's just anxiety is like your blood's pumping. You're
Yeah.
getting ready for battle.
Mm-hmm.
So taking a moment to like feel what that feels like in your body and be like, okay, this is actually going to fuel me
Mm-hmm.
through this, I think is a really good way to go about it. And definitely not to let it, like, don't let that stop you from getting the experience. Because honestly, everyone feels nervous. The imposter syndrome sneaks in,
Sure.
but like you just have to kind of work through it.
I always tell myself that when my heart is beating really heavy like that, when things are intense in trial, it's all the blood is rushing to my brain to make me think faster. I'm more
Yes.
on my feet. I'm more aware of everything that's going on, and I'm so in that moment, and that's a good thing. And so I just kind of lean into it, and it doesn't
Mm-hmm.
really give me that anxiety anymore that I think when I'm up against less seasoned attorneys, it does. And you
Mm-hmm.
can kind of hear it in their voice and things like that. And so you just lean into it. Just do it, right?
Yeah.
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 So you've achieved a lot of successful verdicts, and one of the ones that I'd like to talk about is a $2.1 million verdict for the nurses at Western State Hospital. Can you tell us about that case or the facts of that case and how it led to such a significant verdict?
Yes. So this case, it was 4 nurses. They all worked at Western State Hospital. They were all being targeted by this patient who had a proclivity to target women for violent assault. And it was sort of a sexual gratification that he had in doing that. That was known about him. Our clients reported that they were assaulted in different timelines. And so like at the first one, they had an idea that he would target women. By the second one, he knew he would violently assault them. By the third one, it's like, what are we doing here? And by the fourth one, our client unfortunately had part of her ear bitten off by him.
Oh,
Just
wow.
the most extreme, horrific facts. The case was really complicated legally because we had a huge mountain to overcome in Title 51, so the workers' comp statute. We had to basically fight throughout the life of that case to be able to bring a Washington law as discrimination case despite Title 51.
That's
Because
WLAD is what it's called
yes.
for short, right? So a
Mm-hmm.
WLAD case because there was this L&I workers issue separate from that.
Exactly. So
Okay.
since they were hurt at work, it would trigger an L&I claim because it's, no fault state that we enjoy in Washington. So you automatically get the benefit of L&I if you're hurt at work, regardless of the facts. Then add in the fact that these employees were targeted based on their gender. Well, now it raises an issue under the WLAD. But we had to fight this issue legally the entire case. And so it was and the case, by the way, got continued like 5 or 6 times because it was newly filed during COVID, kept
Oh,
getting
wow.
pushed back. So by the time we got to a jury trial, essentially the entire lockdown period had happened. And we were the first in-person case in Pierce County
Oh,
since
wow.
COVID started. So it's like we're figuring out COVID protocols during voir dire and stuff like that. It was like, for a lot of reasons, it was really different than other cases. But we definitely didn't know whether we were going to have like a slam dunk at trial. It was all very tricky. Our clients were really sympathetic, very deserving, hardworking women. And the jury went with us, and we're really grateful. We wound up getting a really great multiplier on our attorney's fees too, because the case was just so risky to bring.
When you were dealing with that, did you have any fear of, I remember when I did my first jury trial after COVID, one of the jurors got COVID and the judge was like, that's why we have an alternate. It's okay. We're going to figure this out. Did you have any issues like that?
We did have an issue where someone in our office got COVID, like right as the trial started. She just didn't come or participate the whole time, but it definitely made us shift like our approach and
You
how
had to
we
change.
staffed the
Oh,
trial.
gosh.
But luckily, no, we kept all of our original jurors,
That's good.
all
Cool.
of that. Mm-hmm.
Um, and so with that verdict, do you think that there's been a change in what Western State Hospital does or how they treat their employees? Do you see lasting results from the work that you took on in this case?
So I wish I could say yes. All I really have to go off of for like empirical data is that we still have potential clients reaching out to us pretty much every single week for similar issues. In the trial that I did a couple months into practice, we actually were able to secure an injunction as well as our jury verdict, and so that was also a Western State Hospital case, and that required Western State to put some policies and practices into place to help protect employees. So I do like to think that some of that is still lasting and that maybe change is slow but happening. But definitely, we have a lot of people getting hurt over Western State
They get sued a
employees.
lot.
They do.
That's
They
kind of
do.
tough.
Mm-hmm.
I've not been involved in any cases against Western State, but I know just from reading about it, they get sued a lot.
And you know what? The employees who work there are incredibly loyal.
Yeah,
Like they really, really get a lot of fulfillment out of the work they do, and they want to keep working there. It's like it takes a special person to be able to withstand what they experience, and
right.
they want to stay. So that's what makes it really tough.
I wonder if there's a way they could be doing it better, though.
Yes.
It's really sad.
Yeah.
What about technology? Have you integrated? You're a partner at your firm. You
Mm-hmm.
left Gordon Thomas and started your own firm with Mr. Beck. And what's that been like? How have you embraced technology post COVID? All that stuff. Tell us about your firm.
Yeah, so my two law partners are James Beck and Eric Gilman. Eric is very, very tech savvy. He will laugh if he hears me talking about technology as though I know what I'm talking about. I'll say this, I'm an elder millennial, okay?
Elder millennial. I
And
have one in my office. Her name's Elena. She hopefully will watch this, but probably not because she's always like, how do you get the internet to work on this thing?
well, so it's like, yeah, like technology isn't necessarily intuitive to me.
Mm.
I can learn it and kind of gain fluency in like an app or a device if I need it.
Do you go to those Apple classes that are meant
No.
for the older folks?
No, I'm not there yet. But so one piece of technology I use a lot is TrialPad. Like it's run through an iPad and it's a trial device where you basically can present exhibits and evidence, and you can zoom in and sort of highlight and show the jury in real time a document that you're talking about. And I also tend to use it a lot in depositions, actually, because if I plan to present the evidence that way to a jury, especially if it's a video dep, I like to have done it through TrialPad the entire time so that they're seeing a really organized presentation of the evidence.
Right.
So I use TrialPad a lot. And I use some doc review apps too that help kind of cull and organize and synthesize information.
Anything you'd like to share?
I really like Goldfinch. It's a doc review platform that allows you to basically load massive data review sets into one place, organize them, create review sets of them, and just lets you really wrangle, especially if you have cases with a really high, like we'll have cases with 50,000 pages of documents.
Wow.
And so we need to have a way to cull them, organize them, use them in a, persuasive way. So I really like Goldfinch for that.
Awesome. Okay. What has it been like as your transition from being an employee at a law firm to now being a partner at a law firm? Do you see having to wear a second hat of like a business owner, or do you not take that role on as much as maybe the other partners do?
Yeah, so it is a little different. I was a partner at GTH for 1 year, and now I'm a partner at BCG. And I would say there's a lot more business to it. Like, as you know, running your own place, it's like you're not just practicing law, but you're also thinking about marketing and budgeting and sort of hitting your overhead so that you're not stressing out. And as you bring on more employees, that becomes more real. So there is a lot of that, but it's really fun. It's sort of a conversation to be had is like, we get to do this for a handful of decades. What do we want it to look like?
Right.
And working for yourself is pretty great, as you know.
I love it.
Yeah. Yeah.
Well, that's really cool. What about you've written a lot on different legal topics. What types of trends in employment law or civil rights law are you focusing on in your writing lately?
I wrote a bit during COVID and just after sort of the lockdown period because disability discrimination was looking a little different, or the approach to those types of cases in two main categories. One was the accommodation from having to get the vaccine, which
Mm.
really surged and now has sort of died down since the requirement is not as strict for employers. But the other one that's still very much ongoing is the question of remote work as a form of reasonable accommodation. And so it's really interesting because during COVID, I think across a lot of industries, we learned that we can do a lot from home and we can have remote workspaces if we have to. But a lot of employers are now bringing employees back to work in the office. And courts aren't going to approach remote work as a requirement. They very much still give the prerogative to employers of how their workplace needs to look and feel and the requirements that people have. But I have a lot of potential clients reach out pretty regularly that want remote work to be like a protection. And usually it is for a reason, like they have some sort of disability like ADHD or anxiety or something that is very pronounced if they have to go back into an office with a bunch of people. But the analysis is the same. It's whether that is a reasonable accommodation that doesn't create an undue burden for the employer. So it's a very interesting ongoing conversation.
So as part of that analysis, when an employee wants the accommodation to work from home for whatever their disability is, no matter what the disability is part of your analysis, what that burden is on the employer. Like, does that employee already work from a laptop that they could freely carry home? Do they have the same internet speeds to be able to do Zoom meetings with clients? Is that part of your analysis, or is it more based on the employer could pay for those things so it's not an undue burden?
So the undue burden is more of an affirmative defense. The analysis would start at one earlier step, which is the interactive process. And so if an employee asks for an accommodation or even signals that they have a disability that could require an accommodation, the employer has to immediately engage in the interactive process with them. And that could look like asking for medical documentation, although that's not a legal requirement. A lot of people think it is. It could look like asking, an analysis of the essential functions of the job needs to happen to determine whether the employee can perform those with or without accommodation. Then you look at what the accommodation might be and say that somebody asks for an accommodation and they say, I need to be able to work remotely 4 days a week. The employer doesn't have to grant the accommodation the person asks for. They just have to enter the conversation about it. So they could say, it's really important to us that our people are here in person. Collaboration's a really big part of our work. It's energizing to have people here in person. We need you to be here. But what if we gave you your own office? What if we gave you noise canceling headphones? What if we allowed you, some other accommodation that is reasonable? A lot of employees are under the impression that the employer must grant what they ask for.
I see.
But really it's just, is it reasonable? So if an employer comes back to you and says, how about private space? How about noise canceling headphones? It then sort of shifts to the employee to describe why that won't work for them. And sometimes a reasonable accommodation is unpaid time off work, but essentially, or at the end of the day, if an employee can't perform the essential functions of the job, an employer could separate them because of that. So that's where it gets really dicey with this desire to work from home versus it being considered reasonable under the law.
As an employer, I guess my I've not had this situation happen, and I'm sure someone listening to this podcast might have, but in a situation where someone asks for those accommodations, I'm sort of scared to enter into any sort of like separation with that person because I feel like that would open me up to litigation. But you're saying that if the person asks for an accommodation and that reasonable accommodation is not granted to them, that's not the whole part of the analysis. There's this additional factor of, are they able to complete their work? And so as long as the separation is based on the work that they're unable to complete, then that's still not an issue that would rise to potentially a case you'd take and sue me for.
Yeah, it really would depend on what the conversation looked like, because what a lot of employers do is they don't engage in the interactive process. They just say, no, we're not granting you that, and you obviously can't do the job, so you're fired. Or they won't grant it, and then a month later, the person finds themselves on a performance improvement plan and they're fired, et cetera. So
a retaliation type situation. If this person who asks for a work from home situation then is not performing and there are metrics in place, wouldn't my best protection be to put them on a performance improvement plan though?
Potentially, it really comes down to the documentation of it. Because like all of these cases, on both sides, it's what is the evidence going to show happened here?
Right. In my firm, we have a lot of data for the staff. For each role, we have like weekly meetings and metrics. And so if we have this historical data about an employee's contributions, and then they start working from home and those contributions are set, they're supposed to be the same, and we're accommodating a work from home arrangement with the understanding that their ability to do that work is going to be the same. When it's not, that would in theory be a protection to litigation from that employee down the road if they're not able to meet those same metrics.
Potentially, yeah. I think if performance issues predate accommodation requests or are well documented during that interactive process, that is a different scenario.
Oh, so I guess my question, if the employee is not able to meet the requirements of the job before that reasonable accommodation request, you're saying that would actually help the employer, not the employee? Because I would be under the impression that if they weren't able to meet those requirements, it might be because of whatever issues they're dealing with, and that's why they need that accommodation. It would almost help the need for them to have an accommodation, but you're saying that's not the case. It actually helps the employer?
Well, no, not necessarily. It's the language that we're talking around. It's the language under an accommodation analysis is, can the employee meet the essential functions of their job? And that's either with or without accommodation. So certainly there could be a fact pattern where somebody's really struggling to, like, say they're in sales and they need to meet 90% of their sales quota per month and they're only meeting 80, and they disclose like, okay, the reason I can't is because of XYZ medical impairment, either physical or mental. That would be an important component to the analysis. If the employer, though, doesn't engage in the interactive process to sort of bring them back up to speed and give them the accommodation they need to perform their essential functions, that's where it could get interesting.
Interesting.
Yeah.
Good. Okay. So can you tell us about the Washington Innocence Project?
Yes. So I definitely don't want to oversell my participation in that. I did the Innocence Project clinic as a UW Law student and worked on this case that then kept going after I graduated and was asked by Jackie McMurtry, who's the founder and ran the clinic and the Washington Innocence Project for a really long time, asked me to stay on that case. So I did. And we very, very luckily and through a lot of hard work, were able to get that client released, and he's free now. And so the work cannot be understated. It's an absolutely wonderful organization. I'm not that involved with it anymore, but was lucky enough to be involved for a handful of years.
Can you tell people who are listening who might not know what it is?
Yeah, it is a project that was founded in Washington, gosh, like 30 plus years ago. And it was in response to criminal cases of wrongful convictions where decades after the convictions occurred, DNA evidence or other exonerating evidence comes to light that would prove that person's innocence. And so the Innocence Project takes on cases where people have maintained their innocence throughout their conviction, and who believe, either through DNA or witness recantation or other exonerating evidence, that they might be eligible for exoneration. The organization takes those cases and litigates them on behalf of those people. And there are a bunch of innocence projects across the country, and this is the one in Washington.
And so there might be like a Netflix that features you at some point in time.
Maybe. I'll have
That'd
to
be
think
really
about
cool.
who should
Who
play
would play?
me.
Yeah, I was just gonna say,
Oh,
who would
I haven't
play
thought
you?
about that yet.
Wow, you got to think about those things.
Mm-hmm.
And also, who would play your husband?
Right.
That's really
hard.
important too.
It's very hard.
Right.
Someone very handsome.
He's a very handsome guy. What about the fact that you started the first Spanish-speaking free legal clinic in Tacoma? Can you talk about that? That's really huge.
Yeah. So it's through Tacoma Pro Bono, which I know you do a lot of volunteering through.
Love those guys.
Yeah. So I, as a new attorney, volunteered in their general clinic pretty regularly. And you put in your questionnaire whether you have language skills or other, areas that you can volunteer in. And I speak Spanish. And so I would often get linked up with clients who needed a Spanish speaker. And I just started having the conversation with them like 2019. What if we did a full clinic that was just for Spanish speakers? And then COVID hits, lockdown happens right as we're about to like launch the clinic. And so we launched it and it was just by phone. And that's how it's been this whole time. So every month we hold a Spanish clinic through Tacoma Pro Bono where we serve clients. We don't do immigration, criminal, or family, since there are other sort of resources already available in those areas. But anything else, employment, consumer protection, wrongful injury, or personal injury rather, wrongful termination, all of those things people can come to the clinic for.
That's great.
Yeah.
That's really cool. What if someone is listening to this and they have an employment question or they believe they've been discriminated against? Can you tell us a little bit about how to know if someone has a case?
So when a case initially comes to me, the first thing I want to know is what is the evidence? And so a lot of employees who are experiencing disparate treatment in the workplace or even retaliation are very, very afraid of putting anything in writing to HR or management to describe what's happening to them. But paradoxically, that's also the best way to protect themselves legally. If something goes sideways, they get fired, something like that happens. And so when somebody reaches out to me, the first thing I want to know is, okay, you're saying that you had reported to your manager that you feel you're being treated differently based on gender. What did you put in writing to them? And often people will say, I have a ton of documentation, and it's like notes to themselves. And it's critical that employees are communicating directly with their employer, with HR, with management, if something like that's happening. And so that's the first thing we will look at is what's the evidence, what gets us past summary judgment, as opposed to an employer coming in and saying, oh, no, I fired them because of performance, or it was an interpersonal issue. They didn't get along with people. Those are both lawful reasons to fire someone. And most people in Washington are at-will employees. And so an employer can fire you for pretty much any reason as long as it's not discrimination or retaliation. So we're looking to evidence first.
If someone believes that they're a victim of discrimination, besides the documentation, what are things that you might ask in those initial conversations?
Some things that are important are like, was there a change in management between when you were hired and fired? Because there's the same decision maker defense that an employer can bring. If a manager is the one who hires you, then you later say they're discriminating against me based on race or gender, something that's pretty like phenotypically obvious when you meet someone. The employer is going to have potentially a strong same decision maker defense. Other things we look at, Are there any comparators? Like, are there other employees who are similarly situated who belong to a different protected class who are treated better? Those are some of the key ones. Obviously, documentation of things. And if it's a hostile work environment, it's different from like a retaliation claim. Hostile work environment is pretty hard to prove because it has to be so severe and pervasive that it affects the terms and conditions of your employment. So usually you're expecting to see, every day there's a comment or there are slurs written on the bathroom wall or sort of things that you can present to a jury and say, look, this is severe, it's pervasive, it's happening all the time. It created a hostile work environment. So we'll be looking to all sorts of things like that.
Can you give us like a hypothetical retaliation example for people to compare to the situation they might be in?
Yeah, so a traditional view of retaliation would be you have to have engaged in protected activity. So that means you've either opposed what you reasonably believe to be discrimination in the workplace, like you report something happening, or you participate in a proceeding to figure out if discrimination is happening. So if you're a witness, somebody else reports it, you can't experience retaliation. But that first piece is crucial to a retaliation case. So a lot of people will come to me and say, I was fired for retaliation. I reported that I wasn't getting the same amount of hours as somebody else. You could report that issue and be fired for that, and it won't be actionable. What's required is that you're reporting what you reasonably believe to be discrimination. So you would have to say, I'm not getting the same amount of hours as everyone else, and I believe it's because of my gender. Then if you get fired within, I would say, a year of that, you may have a viable retaliation case. And the reason I say within a year is there's case law that says there's a rebuttable presumption of retaliation if the timeline is really, really tight between your protected activity and your termination. So ideal would be like a day, 3 weeks, something super sharp.
Right.
But sometimes you wind up getting evidence that shows behind the scenes, like a story was being built for 7 months to get rid of a person.
How are damages calculated in cases like this?
So we have two categories, economic and non-economic. So obviously first we're looking to economic damage. If somebody is making a lot of money and are fired and don't find a new job for like 9 months or something, that's a pretty good
lost wages kind
accumulation.
of claim.
Yeah. If people have a pension, it's a really important category of damages because it's the value of that can't be overstated. If you go on to a different job where you have a 401k or like not a defined benefit that you're going to receive, that'll go into a damages calculation. And so economic would be the first sort of line of calculations. Obviously, and a plaintiff also has a duty to mitigate their damages. So they need to be out there looking for work and trying to recreate their financial situation. They can't get fired, not apply for any jobs, then we're at trial and we're like, we want 200 grand or something. We have to show like, no, they're out there trying to find work and trying to find a comparable situation for themselves financially. Non-economic harm, so it's the emotional distress damages. Under the WLAD, well, actually just under the Washington Pattern Jury Instruction, it defines non-economic harm as multi-category. It's stress, despair, emotional distress, humiliation, loss of reputation. There's like 8 or 9 categories that all go into emotional distress. And so I think it's smart to assess each of those separately because the humiliation of being fired in a meeting with all of your coworkers is different than the stress of having to then cash out your 401k to live off of. Those are 2 separate categories. You want to try to quantify them as much as you can because it's a really tough category of damages to calculate. It's not, there's no formula to apply.
Got it.
So
the best thing someone could do is reach out to you.
Yeah, absolutely.
So how would someone reach out to you after listening to this podcast to either build the correct systems at their office to not violate the law, or as an employee, ask you to represent them?
So I would say the second category is mostly who would be reaching out to me. We don't do a ton of employment advising, but I do have referrals if people need that. But if you have an employment case, a personal injury case, consumer protection, or breach of fiduciary duty, you can reach out to us online is the best way, bcglawyers.com.
Okay.
Fill out a questionnaire, and our intake team would reach out pretty quickly for more information.
Awesome. Awesome. Is there any advice that you'd like to give to young attorneys listening to this podcast?
Yeah. Young attorneys and also like maybe people in law school, I would say, really assess where you come from and figure out your strengths within that for being a lawyer. Because I think once we get to law school, there are a lot of assumptions about our shared life experiences that, we're all on the K through JD track, or we all are like sons and daughters of lawyers or things. And I know for me, when I got to law school, I was like, oh God, I don't belong here and I don't have anything in common with anyone. It wasn't true. That's just how I felt. But it's because I'm a first generation college graduate. I completely like stumbled into law school through my work experience. And now when I think about so anyway, in law school, that was sort of something I hid, and I didn't really know how to talk about it, that I had a different socioeconomic background. Now it's something I use as a strength a ton. Like those moments when I'm prepping for trial or I'm nervous about something, I have a pretty deep well of resilience and sort of self-reliance that I feel really lucky to have. So I think if you can find whatever that is that sort of makes you, use that as an advocate and as an attorney, because I think what this industry needs is more authenticity always. Right. I'm not saying it's lacking, but that there can always be more. And certainly trial work, it's really necessary to be who you are.
Right.
So like figuring that out as early as you can, I think is really helpful.
Great advice. All right. Well, thank you, Janelle, for joining us and sharing your journey and your insights. We look forward to seeing your continued success and your positive impact on the community here in South Seattle, Tacoma, all over Washington.
Thank you, Josh. Thanks for having me today.
Thanks.
This was fun.